All right, welcome everybody to our webinar series. I am a firm believer in getting these things started right on time. So with that being said, I'm going to turn it over to Judy Hanrahan and let her introduce herself and get this talk underway.
Hi, everybody. My name is Judy Hanrahan. Let me share my slides. My name is Judy Hanrahan. I'm a lawyer by training. I have a master's degree in philosophy. I am the Assistant Dean for Faculty Affairs and Learning Innovation at Roseman University College of Medicine, where we're new medical school getting ready to go, or going up for accreditation now. I'm also an assistant professor of justice and health humanities. I'm just gonna go forward with the slides. Let's see. So the first slide, CME statements. The School of Medicine of the University of North Carolina at Chapel Hill designates this live internet activity for a maximum of one category category 1 credit. Physicians should claim only the credit commensurate with the extent of their participation in this activity. I don't have any financial disclosures to make, although according to the disclosure statement, I'm not required to. This clinical faculty development series has a goal of providing faculty development to a broader audience of those interested in clinical medical student education, including medical students, residents, fellows, clinical, academic, and community physicians. It's a 3-year series. I think that we are in the 3rd year. 9 webinars per year, and they usually happen on the 2nd Thursday of the month at 1 p.m. Eastern Standard Time on Zoom. These are based on the Guidebook for Clerkship Directors, 5th edition. Series 1 and 2, the recordings are available on the ACE website, and I think that Gary said they're on there's an ACE YouTube channel as well. The 3rd year series, so we're here in February 15th, and I'm doing legal issues in clinical medical student education. The subsequent, there will be, looks like 4 more in the series, and you can see those on the screen here. So this talk is based on chapter 29 in the clinical faculty development series, chapter 29 in the Guidebook for Clerkship Directors. And the chapter is basic legal issues and considerations for clerkship directors.
Oh, so thank you for responding about the WAMC conference so quickly.
Oh, sure.
Sometimes I don't get a response.
I think that Judy, you are unmuted. Sorry. So I'm not the author of this chapter. The authors were Staji Boy, Peter Eveland, and Jennifer Gonzalez. The objectives for this talk today are to, you'll be able to walk away from this and define an educational record under FERPA, describe 2 exceptions to FERPA protections for educational records, describe the importance of appropriate institutional policies regarding feeding forward information about struggling medical students, and recognize 3 situations where clerkship directors should involve medical school administration in handling a medical student issue. Just a disclaimer, this content is provided for educational purposes. It's not legal advice, and it shouldn't be substituted for the particularized advice of your own counsel. Like medicine, law is, and legal advice just depends so much on the facts and circumstances. And this talk is going to be necessarily broad because we're covering legal issues across many different areas of the law. So I will do my best to be able to answer your questions. And if I'm unable to answer some particular question you have, I will take your information down and try to get back to you. Let's start with FERPA. FERPA is the Family and Education Rights and Privacy Act. FERPA applies to, I think, every medical school, but it applies to schools that receive federal funding or enroll students who receive student loans. Therefore, it likely does apply to all U.S. medical schools. Under FERPA, people are not allowed to, educators and people at universities are not allowed to disclose personally identifiable information without written consent of a student. So this requires us to look at what's an educational record. Those are what's protected. So personally identifiable information in educational records. So educational records are every form of written communication about a specific student should be considered part of their educational record. This includes emails. This includes documents that are, evaluation documents, really anything that the school is containing information about a particular student. Under FERPA, students have the right to consent to the release of their educational records, to review their educational records, and to potentially amend their educational records through a process. FERPA also recognizes a separate set of records called treatment records. So those are the records related to enrolled students maintained by university clinical services. So this includes like student counseling services, student health center, and even university practice plans where students might be seen at that practice plan in addition to the general public. And so it puts those practice plans in a kind of interesting situation where some of their medical records are governed by HIPAA laws and some of the medical records are governed by FERPA laws. All of the laws require, both sets of laws require confidentiality and privacy protections, but they're just a little bit different. So that's a little bit beyond the scope of what we can talk about here, but there is a really useful, if you're interested in this interplay between HIPAA and FERPA and treatment records, there's a nice guidance document by the Department of Education. And so I put the link here, and I've made a QR code that you can scan with your phone to look at that and read that document. I found it particularly interesting. I was not aware of this whole interplay before I was preparing for this talk. So it's interesting. Certain things are not protected by FERPA. Personal knowledge or observation or information you heard orally from others, that's not covered by FERPA because it's not in an educational record, right? So if you observed it, it's in your head, it's not in a record. That is until that information is used to make a determination to generate an educational record. So you are witnessing, or a faculty member is observing a medical student do a procedure or practice a HIPAA physical. As soon as they write down their impressions of that into an evaluation or an assessment of that student and that student's performance, it becomes an educational record. And that personal knowledge now is, because it's contained in an educational record, is protected. So someone would, the faculty member would need to keep that private. Personal memory aids are not protected by FERPA. So if you take handwritten notes, as we've got the hand there, if you take handwritten notes about a student and it's only to jog your own memory, that's okay. And in fact, I would encourage people to keep records of, especially when you're dealing with students that are struggling, keeping records of the interactions that you've had with them so that you can have, but just as a personal memory, this is not going to be something that you're sharing with other people. It enables you to really go back and remember all the stuff that you've done and can help protect you in the case that a student were to come forward and say that they didn't get the help that you gave them. Additionally, law enforcement records are not included in this. FERPA has an emergency exception, so it allows the covered entities to disclose personally identifiable information from educational records to appropriate individuals when necessary to protect the health or safety of the student or other individuals. The guidance from the Department of Education on this lists parents, law enforcement officials, public health officials, and medical personnel as the type of appropriate individuals to release personally identifiable information to. And then when they're talking about necessary to protect the health or safety of the students, they really are focusing on impending or imminent emergencies, things like natural disasters, terrorist attacks, a campus shooting, or an outbreak of an epidemic disease. In these cases, written consent to disclose personal personally identifiable information is not required by FERPA. However, general unspecified concerns for patient safety are probably not covered under this emergency exception. So if you have a student that's rotating through your clerkship, and you're concerned about them going forward into the next clerkship and possibly causing harm to a patient, you can't use this emergency exception for that, to make that disclosure to the next person. School officials are, however, allowed to disclose personally identifiable information to other school officials, including other preceptors or teachers who have a legitimate educational interest in it. Any duty a medical educator has to future patients of a particular student should be fulfilled through appropriate supervision and providing accurate, objective reports to medical school administrators. So I really highly encourage you to use your school's reporting mechanisms. Gossiping and talking about a student, feeding information forward to another clerkship director or another faculty member has the potential for biasing people against a student. So we suggest some caution there. So to see how well we understand this, I want to give this case. You're a pediatrics clerkship director and you receive a phone call from a current clerkship student who states that they saw another student sideswipe a vehicle in the parking lot and proceed to the student parking area. The student notes they believe that the other student has a drinking problem based on previous experience and is concerned that he might be drunk from the previous night. So if everybody could get into the chat and just answer the first question, just type really quickly. Is this phone call an educational record? Type whether you think this is an educational. Bill says no, that's correct. It's not an educational record because it's a phone call, right? Now, what if the student sent an email instead of a phone call, sent an email to you as a clerkship director? Does that become an educational record? Does anybody have information that way? Catherine says yes. Yes, once it's put in email, it becomes an educational record. Does it change how we respond? It's still here. Does it change how we respond to this situation? No, it's not going to change how we respond to it in this situation. In this situation, the student, you've got a credible reason to think that this person might not be functioning properly. So either way, you get a phone call, you get an email, you need to probably get the student out of the clinical setting and consult your fitness for clinical contact policy. And of course, report it to student affairs immediately. So the fitness for clinical contact policy, every institution should have one of these. If you're not familiar with your institutions, you should become familiar with it. If your institution does not have one, you should advocate heartily for them to have one, get one. So you want to follow this policy for every student. So you're going to use that policy as a guidance for how to handle this situation where the student is potentially intoxicated at a clinical site. You need to train your faculty to recognize fitness for clinical contact concerns, both about themselves and others. So these fitness for clinical contact policies will include things like sleep deprivation and things other than just substance abuse. And then you want to immediately involve student affairs and/or academic affairs deans. It's really important to not just handle situations like this completely within your clerkship because it has the potential to disallow the administrators from some patterns, student patterns. So you want to make sure to use reporting mechanisms. And those reporting mechanisms, especially if they're institutionalized and policies, have been vetted or should have been vetted by legal counsel and should be in compliance with FERPA. So I want to take a little intermission here to talk about legal liability. In the book chapter, there's a subheading about how to avoid lawsuits. it's not always my favorite way of thinking about legal issues, because in medical education, sometimes there's no avoiding the lawsuits. Sometimes it's preparing yourself for eventually being sued. Students that get kicked out of medical school have lost lots of money a lot of times, sometimes their whole dreams, and they will fight, the schools about that. And so it's just a reality of where we are. So when we're talking about these different legal areas, I wanted to give you a little sense of legal liability. FERPA is the sole responsibility of the university. So if you violate FERPA and, inadvertently or purposefully disclose protected student information, students have no private right of action against you. So that gives you a sense of probably erring on the side of protecting patients and protecting, other students in this situation. You always want to contact student affairs because they're the experts in the FERPA area, and should know what the reporting mechanisms are. We talked about feeding forward policies. Schools should have feed forward policies. These are policies for handing off struggling students to the next clerkship. Having feed forward policies formalized are important to avoid bias in future evaluators. They should be developmental in nature. Faculty should be trained, especially when they're dealing with struggling students, that their role is not to diagnose students. And if your school doesn't have a feed forward policy, advocate for one. So I've linked an article here that's revisited. It's called Revisiting Feed Forward, Promoting a Student-Centered Approach to Educational Handoffs, Remediation, and Clerkship Success. This article was really good, and it describes 4 different feed forward approaches at different universities. And they all use clerkship directors as kind of central person to making this feed forward. But there are clear guidelines about who gets put into this track of struggling student, what are the criteria there? And then how can we minimize bias and use it as a developmental tool instead of as a tool that students could see as detrimental to them. So dealing with difficult students, it's important to flag student difficulties, like I said before, to administration to allow for pattern recognition. It's important to document objectively, including how you responded to situations. And then I just want to put this out there. If you miss something in your first response to a difficult student, it's happened to all of us. Don't be defensive and hesitant to go back and readdress the situation. Think of it as a role modeling opportunity. And here's some statements you can use. I thought of something else that might be helpful for you. Or yesterday I neglected to mention whatever. Don't be afraid to come back to these difficult conversations with students. And the other tip is to offer to make necessary phone calls with the students. Let's call student affairs together and report this. So we're modeling professional behavior and teaching the student a really important professional skill about how to make, say, a report about a student that they're suspecting is intoxicated, so that they get that practice fulfilling those kinds of professional responsibilities. When reviewing students, I'm going to suggest you follow the guidance on assessment and feedback from chapter 17 in the clerkship or the guidebook for clerkship directors. When we're describing unprofessional behavior, we use objective statements and descriptions of the behavior. So there's no need to characterize things as egregious or wildly inappropriate. You can, if it is indeed egregious what happened or wildly inappropriate, you can just type up, X happened, Y happened, this was said, that was said. It's very boring reading. We're not writing a novel here. It's just factual statement after factual statement. This was said, this was said, this was said, I said this, I did this. And you can trust the reader to come to their own conclusions. Legal concerns when reviewing students or feeding information forward outside of a formal process. would be defamation and or harassment claims that a student could make against you. So defamation is defined as a false statement of fact concerning a person, publication or communication of the false statement to a third party, a degree of fault on the person communicating the statement. So you're doing this wrongfully, and harm to the reputation of the person defamed. So it's important to know that truth is an absolute defense against defamation, but, oh, sorry, went the wrong way. You still have to defend against these kinds of lawsuits. So defamation is a private right of action against the speaker. So the student might sue you individually. And if the student is claiming discrimination, discrimination laws either explicitly include a private right of action, or the courts have implied a private right of action. So I see a question in the chat. I'm going to encourage everybody to raise your hand if you have a question so that we don't miss it. I don't mind answering questions in the middle here, but we do have time at the end. So I'm going to read this really fast. Dawn asks, how would you recommend approaching the student in your example who one faculty member or we have another student falsely accuse another student of a professionalism issue? So if this is why you're involving student affairs, is that they're going to have to do the investigation. I've got some advice on further slides about when it comes to discriminatory stuff for professionalism issues, unless it raises to the level where you would actually need to like pull the student out immediately. You're going to just deal with student affairs on those questions. Let me give another case. In the mid-clerkship review, you're with a struggling student and the student discloses a disability or other medical issue that is impacting their clerkship performance. How do we go forward with this? So let's talk about the Americans with Disabilities Act and Section 504 of the Rehabilitation Act. First thing we wanted to do, there's a theme here, you guys will find, flag it to administration. There are procedures and policies in place and people with expertise in these areas that you want to get involved. One thing that you can do before, say a student flags this, and like I said before, I strongly encourage you to say, hey, let's call the disability office right now together and model how to ask for help if the student hasn't already been identified and has accommodations in place. Help them through that. You can work with a student to identify easy accommodations and implement them immediately. So there's no rule under 504 or ADA that that you have to go through this like super formalized process to do accommodations, especially if they're easy accommodations and they're not going to impact anything. So I've listed the 4 questions on here that you want to consider when making an accommodation decision. These are really the schools making these, but you can think about these as well if you're making a on-the-fly decision as an educator. So would the proposed accommodation result in a failure to meet the program's technical standards? Would the accommodation legitimately jeopardize patient safety? Would the proposed accommodation pose an undue hardship to the institution? So I'm going to tell you like a story. I have a friend of mine who moved from her son from one school district to another. So this is not a medical student. This is a middle school student. So the student has comes from the first place. The student has all sorts of identified abilities and accommodations in place, including they're allowed to redo work that's below 70% until they can get it above that 70%. Come to the new school district, the new school district has that policy implemented for every student, right? So some of these things that actually might be beneficial for everybody to have. It's not even necessarily an accommodation. Maybe that's actually just an appropriate educational policy to have. So if you can work with a student to modify so that they are at a clinical site, a different clinical site that is more amenable to, say, even like somebody broke their foot and is having a hard time just temporarily getting around in a certain place, but there's a different clinical site that would be less arduous or burdensome for that student, you can go ahead and make those things. But the student does need to go through this formal process to get their accommodations, written down so that future clerkships have that information and can be proactive about ensuring that the student doesn't lose any educational opportunity based on disability. Just a note on technical standards, because the previous slide talked about is the student able to meet the technical standards? This is one of the things that just gets me going. Technical standards should be functional rather than organic. So organic technical standards focus on specific physical, cognitive, sensory, or behavioral abilities that a student must demonstrate without accommodation. So where functional technical standards focus on competency outcomes without delineating how a student achieves them. So medical educators, in my experience, have tend to assume how a student is going to meet a certain standard. Okay, so the technical standard might say something like, a candidate must be able to speak, hear, and observe patients in order to elicit information. So that's an organic standard. A functional standard would see a candidate must be able to elicit information from patients, if that's really what the core of it is, and not make an assumption about speaking, hearing, right? There are so many adaptive technologies, interpreters, different things that students could use to meet that standard. So I've copied this article here if anybody wants to read more about that. Also, I cannot recommend enough this book, Disability as Diversity. It's a guidebook for inclusion in medicine, nursing, and the health professions. There's a chapter called Clinical Accommodations and Simulation in this book, Disability as Diversity. This QR code will go to the actual book, but this particular chapter is good, and I'm going to show you some of the things. The authors of that chapter go through literal specific accommodations for students, including, what manufacturers manufacture different kind of adaptive technologies for different kind of stethoscopes here, I think is what this one is showing. They also very specifically talk about clinical accommodations in different settings, in inpatient emergency settings, in the OR. I didn't screen grab them, but there are also things about how to accommodate for specific kinds of procedures, like pap smears or rectal exams for students with disabilities. So the authors really go into detail about that in a nice way. So I cannot recommend this book enough. When it comes to the ADA in Section 504 of the Rehabilitation Act, it applies to schools, but there's a private right of action for discrimination based on disability status. So that means that you could also be named anonymous suit. Let's talk about mid-clerkship review and discrimination. This is a case during the mid-clerkship review, a struggling student discloses that they have been the victim of discrimination by a fellow, 2 residents, and an attendant. In undergraduate medical education, students have a right to an education free from discrimination based on race, sex, religion, disability, or other protected statuses. This is something you absolutely have to address immediately. Let's talk about sexual harassment. There are 3 kinds of sexual harassment. There's sexual assault and a rape, or quid pro quo. So this for that. If a student alleges that a faculty member said, I will give you a glowing recommendation if you go out on a date with me, that's quid pro quo. Any single incident of that is sexual harassment. A sexual assault or rape, also sexual harassment. Hostile educational environment is a little bit broader. It's a pervasive set of demeaning, degrading, and offensive conduct. So no one, just a student saying, okay, there was one comment that was made or 4 comments that were made in different times about stuff, depending on how pervasive, it's a really fact-specific thing. You're going to want to address it, of course, with those individuals, but it doesn't necessarily rise to the level of sexual harassment. You still want to nip that stuff in the bud, but it's not necessarily sexual harassment, just 1 or 2 comments. And then retaliation for making a complaint. So if the student makes a complaint and you determine, okay, it wasn't pervasive, or the Title IX office at the school just determines that it wasn't a pervasive set of demeaning, degrading. Yes, there were demeaning, degrading comments, but they were not pervasive. But then people start retaliating against that student for making that original complaint. That's prohibited under sexual harassment laws. So responding to sexual harassment, you're always going to go to your institution's Title IX coordinator first. Talk to human resources for employee, if it was an employee accused of sexual harassment. So for serious violation, sexual assault, quid pro quo, sexual harassment, you have to stop other students from rotating with that person until an investigation can be completed. For serious infractions, or for less serious infractions, the comments need to be addressed with the offending parties using human resources and other institutional guidance. So we're working with HR, the Office of Academic Affairs, to figure out an appropriate way of addressing this with the attending. And then if the student has said, okay, another student did it, that's when you're going to involve student affairs as well. Here we get a case. A pregnant female medical student gets persistent comments from both male and female attendings about her choice to become pregnant in medical school. Many of the comments are offered as jokes or purportedly good-natured barbs. She's constantly asked about what specialty she will be pursuing and guided away from her preferred specialty because of her budding family. Other female students are told, don't be like her. This is pregnancy discrimination. And so if the student discloses this to you, you overhear it, it needs to be addressed. The faculty probably needs some faculty development on pregnancy discrimination. And this is something that you might want to feed forward, not in terms of this particular student, but in terms of there may be a need in our institution for some faculty development around this kind of statement, especially around pregnancy discrimination. So you want to make sure that the student doesn't face this kind of treatment in future clerkships. That goes towards this pervasive set of situations where the student is hearing it everywhere, can't get away from it. And that really starts to amount to harassment if it's not addressed. So you might want to take some proactive steps to alert other clerkship directors or the Office of Academic Affairs. Hey, there's a need here. This student probably is not going to want to be singled out. I was a pregnant law student, so I can tell you that people notice it and will say things like, why are you doing this? So you can talk to other people in the clerkship and ask, did anybody else notice this? That gives you the ability to truthfully tell people, you know what? I heard this from many members of the team that this happened to a particular student. You don't need to say the student's name, although if there's only one female pregnant student, then it'll probably be pretty clear who you're talking about. But try to keep it away from that particular student as much as possible to avoid others, possibly making more inappropriate comments to her. Harassment based on race, you need to report that to student affairs or your institution's reporting mechanisms first. Consider including the student in the process. For serious violations, including instances of overt discrimination, you may also want to stop other students from rotating with that person until an investigation can be complete. You're not the investigator, you need to report it to somebody else, and there needs to be an investigation because as has been kind of noted in the chat, students may make reports of harassment or professionalism violations to divert attention away from their own deficiencies. I think that that's completely possible. But you can't just make that assumption that that's what happened. There does need to be an appropriate investigation. For less serious infractions, such as racialized microaggressions, address the comments with the offending party, using human resources and or other institutional guidelines. So this is a particularly something that I've written a couple of blog posts about that I'll share with you guys links to. Patients might want to exclude undergraduate medical students from participation in their care based on a protected category. So a patient could say, I don't want female, I don't want a woman in the operating room with me. I don't think women should be surgeons. Okay, so that student that's being excluded is not being excluded because they're a student, they're being excluded because they're a female student. Or a patient could say, and patients do say things like this, I don't want a insert like racial epithet here in my room, right? How do we address that? And we need to not just address this, we need to address this as faculty members, and faculty need to be trained to address this kind of thing. Patients have the unequivocal right to refuse to have undergraduate students participate in their medical education, or sorry, to participate in their medical care. This is true even if a patient is refusing medical students based on that protected characteristic. Well, if that's the case, if they can be racist, sexist, homophobic, whatever, against a particular student, how do we protect that student from discrimination? We protect that student by not allowing any other students to work with that particular person. So if the student hasn't been explicitly excluded, but they've just been subjected to a racialized remark or a sexist remark, the student should have the option to continue working with that patient or family who's not necessarily excluded them, but has been inappropriate. The student should be coached through working with patients, family. This is an opportunity to talk about professional responsibilities, ethical obligations. The student needs to be debriefed, and the patient needs to be told unequivocally that this is unacceptable. And in certain cases, if it's in an inpatient setting, some hospitals have behavior contracts and different things that they will use. So here's a link to how to handle a racist patient with medical students. And there's some tips on debriefing with students and addressing with the patient in this one. So just the bottom line, if an undergraduate trainee is rejected from participation in the patient's care based on protected characteristics of that particular student, no other graduate trainee should see that patient. So every patient encounter is a learning opportunity. So it's easy to see in like a surgery clerkship that getting to scrub in and even just watch a surgery is an educational opportunity. And if a patient were to exclude a student and say, no, you know, I don't want a whatever kind of student in the OR with me, and you say, okay, but we don't want to let this opportunity go to waste. This person isn't objecting blanketly to student participation. Let's get another student in here that doesn't, you know, that the patient will be acceptable or accepting of. Well, that second student is getting an educational opportunity that the first student was denied based on a protected characteristic, and that's unacceptable. That's literal discrimination. So in that situation where there has been a bigoted exclusion of an undergraduate trainee, no other graduate trainee can see that patient because it's an educational opportunity that that person would be denied based on that protected characteristic. Oh, I think I have the same slide there. Patient exclusions of graduate medical students. Employers have a duty to respond to the bigotry of coworkers and customers, clients, patients, contractors. Residents and fellows are employees, and you cannot make staffing decisions based on bigotry, except in very few cases. Never for race, ethnicity, religion, or ability status. There are some court cases where sex concordance between care providers. There are no cases specifically on physicians because physicians tend to handle requests, patient requests like this internally. So within the physicians will talk and decide, okay, someone else can see this patient. So a graduate trainee should not be required to work with a patient who's bigoted. Okay, you have to go see that patient. It doesn't matter. It should still be their choice, but they should be coached through how to do that. This is a part of modern healthcare in the United States, unfortunately. So there's another, there's another article about how to deal with racist patients with residents and fellows that can kind of help you work through that. Another topic in the chapter was curricular content, legal curricular content, such as mandatory reporting requirements, public health reporting, say dog bites, communicable diseases, child elder abuse, state duty to warn others, so Tarasoff type rules. These are all curricular kind of content. These are things that medical students are learning because of whatever that particular, okay, you're working in the emergency room. This is part of what it is to be in an emergency room, is making public health reports for dog bites. You know, students need to understand their child abuse reporting requirements when they're on their PEDS clerkship. Students should know EMTALA when they're, you know, emergency medical treatment and labor act when they're in the emergency room. This kind of content, training material can do double duty for you. So it can be for learners and for faculty development. So I work in faculty development. It's really important for your faculty to be giving students the same accurate information about the law that they may be getting in like a legal jurisprudence class or somewhere else in their undergraduate curriculum. So just encourage you to engage in faculty development around some of these topics. And then Bruce Morgenstern had asked me to possibly comment on advising students and student clubs. So there's research out there, and I should have included the stats, but I didn't, and I apologize for that. There was a significant number of program directors who admitted openly in the survey that they look at applicants' social media. So residency program directors are looking at students' social media, and so students need to be aware of that and be using social media appropriately. They should need to be aware of the school's social media policy, especially regarding logos. Personally, I would never create a social media post that is like take a picture or video while at a political site, either as a student or employee. I see this all the time. I happen to love TikTok, and there's amazing content on there from medical students. I have learned so much about the experience of being as a lawyer who's never been through medical school. I've learned so much about the first person medical school experience from watching medical students talk about their experience on TikTok, but sometimes they're sitting in a call room or they're at doing this while they're on site at a clinical space, and that should just really be discouraged. Mostly what I see now is students and people in their car. That's a safer bet. The students need to be aware of what message they're sending to potential program directors and maintain professionalism in their social media use. And then when advising student clubs, especially when it comes to potential like controversial speakers or inviting people on campus, I would consider professional obligations and the obligations that we have as professionals before inviting controversial speakers. So that's how I would coach students through making kind of decisions about that. If somebody is, an anti-vax scientist, they really need to think about the values of the profession before inviting that person to speak. So that's just a little bit of advice. So I've got questions, but before we get to questions, I should have put a last slide in here, just wrapping up the legal liability issue, because if there's one thing that you walk away from this, I didn't put it as a learning objective because it's not necessarily the point of this, but you should have your own umbrella policy for liability policy. As a physician, as a medical educator, you are subject to getting named in a lawsuit. And in almost all cases, your institution will provide legal representation for you. But lawyers can be nasty, and lawyers can try to and will claim, oh, this particular thing that this person did was outside the scope of their employment, and so we're not going to cover it. You know, an insurance company could say, we're not, that's outside the scope of what's going on here. You still have to mount a defense to that, even if it is a defamation case and you have truth as the defense. You're not an attorney. You want to have a professional on your side doing that for you. So buying an umbrella policy as part of, so my husband's a physician, I'm a lawyer. We would never go without having an umbrella policy. So it's just part of our homeowners insurance and vehicle insurance adding, and it's pretty cheap, like a number of hundreds of dollars a year for us to have a policy that covers us in case we get sued by somebody in a way that's not covered by other things. And that is helpful for, even if you get in a motor vehicle accident, oh, people see deep pockets. You're a doctor, you're a lawyer, you might get sued. So that's my just personal advice to you about making sure that you're protected, that your family's protected all the time by having that umbrella policy. So now we will go to questions, and I see one in the chat, so I can start there. Can you comment on any cases, suits against medical schools for wrongful graduation of a student who's had academic or professional issues and who later harmed a patient? I have not seen, I don't know anything about that. So that is definitely something that I will look at. I don't know if there are cases of that. It would be a hard, I think it would be a hard case to make because there are so many intermediary things that happen that break that causation, like licensure and graduate medical education and stuff like that. So I guess I could possibly see it in a graduate medical education context where a student harmed a patient. In graduate medical education, there's the idea of respondent superior. So as a supervisor of, I'm going to stop sharing so I can just see it in these spaces. As a supervisor of residents and fellows, you'll probably be named if they do something wrong, because this idea is that you're responsible for your supervisees and the actions that they take. So you want to take appropriate supervision of trainees. But yeah, I imagine that would be a pretty hard case to me. Anybody else have questions? Or just anything that you want to hear about more?
I'm a little curious myself, as far as the feed forward aspect of this is concerned, because in a competency-based medical education model, being able to provide insights about performance as people move along is really vital, because that way you can customize the feedback and help that they need. What would you recommend people doing with regard to that, so that you're not violating FERPA in some way, shape, or form? Because I know that there's some schools that basically, I mean, they basically dropped the iron curtain and said absolutely no forward feeding of any kind. And that really doesn't help if you're going from one clerkship to the next, and a student may need some attention, not in a biased way, but attention to help them to get to a minimum level of competence that they need to get to.
So personally, I think that feed forward policies are vitally important to professional development and growth, and having those conversations. That's why having that policy is so important, that it's done in a structured way. I don't think that, in my professional opinion, now this is not legal advice, but in my professional opinion, I don't think that feeding forward information, even in an informal way where there's no policy from one clerkship director to another, from one attending to another attending, violates FERPA in any way, because there is that exception for educational need to know, right? If there's something important that you feel the next attending needs to know that's going to have this student with them, then I would err on the side of giving that information rather than not giving it, because there is that broad exception in there. And also, I mean, just the pragmatics of it, there's no private right of action in that law. So I personally wouldn't be, have there been successful suits alleging feed forward cause harm? So suits that are talking about feed forward would be about discrimination or bias, right? And I am 100% sure that there have been lawsuits about the bias aspect of that, right? So that's what the concern is that you're going to be biasing the next person. Schools are pretty well protected, and that's something that the school would be fighting, right? So you might be named as somebody and you would have to be deposed, and it's not fun. But schools have pretty wide latitude in their assessment and evaluation of medical students or assessment of medical students. And as long as you're following, you know, procedures and policies and having objective assessments as much as possible, you're pretty safe there. Now, if a student is alleging, what's more likely to happen is the student's going to allege I was discriminated against for some other thing using this feed forward process. The article that I put a link to is really beautiful. In a lot of these cases, the students are in that room. They're part of this process as part of their professional development. And I think what an invaluable experience for somebody that's struggling. We all struggle at times. And they're really meant to be a developmental process. And so, especially if the whole entire process is geared toward that developmental, you know, helping the student get through, I don't think it's problematic at all. Now, this is not my first gig in medical education. I have worked in another medical school, and I have seen people just hell-bent on this student shouldn't be a doctor. That's where it goes. That's where it goes wrong. When it becomes a personal, I'm going to do everything in my power. I'm going to tell everybody I can. I'm going to do whatever I can to try to stop this student. And I can't say that that's frequent, and you know, it was a number of years ago, but things like that can happen, and that's where you would see a feeding forward issue.
Other questions?
Hi, and thanks very much. I just had a question regarding COVID and, you know, the policies regarding keeping, you know, students away. Clearly, there's safety issues for all the other people working with the student as well as the patients themselves. If the institution has developed a certain policy, but an individual director, you know, feels that the student even, you know, should stay, you know, out of the clinic or in a certain setting for a longer period of time. Have you come across any cases related to, you know, COVID or its implications?
No, I'm not aware of how places are dealing with that. You know, in preparation for this, what I did find was liability issues about when they were having medical students practicing as physicians when they were in the COVID, especially in New York and some of these places where they were so overwhelmed and they were at schools were graduating students early or doing different kinds of things. States were issuing provisional licenses and liability issues with that. That was the only experience with COVID. I think following schools need to be following and directors and faculty need to be following CDC guidance on that and not be substituting their own medical judgment. But I see that a lot where, well, you know, I think that this is, you know, they're not ready yet or whatever, but if they've met the criteria, you know, that the CDC has put out, then they should, that should be the guidance. We have 5 more minutes if anybody has anything else that they're interested in talking about.
All right, it doesn't seem like there is.
thank everybody for your time, and I think, oh, wait. Yeah, if, Gary, if you're okay, I think that we can be done.
Yep, I think it's great. Thank you again for doing this presentation today, and thanks to Bruce for lining you up. So we could cover this topic. It's a pretty important one for everybody. So we appreciate it tremendously.
Yeah, hopefully,
enough.
hopefully you guys are interested in things. I pointed you at some places to get more information. And it's a big, broad area to cover everything.
Yeah. And that's, we make it.
All right, have a great afternoon, everybody.
Thank you.